The Equal Protection Clause is a part of the 14th Amendment of the United States Constitution created to protect individuals' rights from discrimination. It states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The Equal Protection Clause does not mean that everyone has to be treated equally. People only need to be treated with equal rights if they are under similar circumstances. Under this clause, the United States government cannot deny anybody equal protection under the law because of race, gender, or sexual orientation. Most recently, this has been an issue in the state of Oklahoma in the case of Bishop v. Oklahoma, where a recent ban on same-sex marriage has just been ruled unconstitutional.
The 14th Amendment was proposed on June 13, 1866, and ratified on July 9, 1868. The Equal Protection Clause has been seen in many famous court cases involving racial and gender equality. The most famous case involving the civil rights movement was 1954's Brown v. Board of Education. This is when the court ruled that racial segregation in public schools was unconstitutional under the Equal Protection Clause of the 14th Amendment. Gender equality was promoted in the 1971 Reed v. Reed case when it was ruled that no person may be denied equality before the law because of his or her gender. Currently, the Equal Protection Clause is applied in many cases involving sexuality and same-sex marriage.
All of this considered, the 14th Amendment's Equal Protection Clause could arguably be on the list of the most important clauses in amendment history. Without this amendment, interracial marriages and desegregated schools would not be considered legal. Women would not have voting rights or equality in the workplace. The Equal Protection Clause has been defending the rights of citizens for decades and has been assuring citizens of their protection against segregation. The unique characteristic of equality seen in the United States would not have been made possible without the 14th Amendment. As it is now, this clause is being used in court cases to defend same-sex couples seeking marriage.
The Equal Protection Clause has been seen most recently in the case of Bishop v. Oklahoma. Same-sex couple Mary Bishop and Sharon Baldwin first filed their case against the state 9 years ago in November of 2004, along with Gay Phillips and Susan Barton, when a ban on same-sex marriage was voted into place with a 3-1 victory. Phillips and Barton were legally married in Canada and have recognized civil union in the state of Vermont, while Bishop and Baldwin have been together for 17 years. Both couples wanted the right to marriage in the state of Oklahoma. After waiting for 5 years for their case to be heard, in 2009 they were told that the case did not have standing, so they had to remove the governor and attorney general as defendants and had to refile the case. Many of the issues same-sex couples have faced stem from the DOMA, or Defense of Marriage Acts. A piece of this legislation states that legal unions do not have to be recognized when they were performed under different jurisdictions. Finally, on Tuesday, January 14th of 2014, the ban on homosexual marriage was ruled unconstitutional by U.S. District Judge Terrence Kern, in legalizing unions and recognizing those performed under different jurisdictions. The ban was ruled a violation of the Equal Protection Clause because it was denying a homosexual person of a marriage certificate that could be received by a heterosexual person, therefore denying someone equal rights as another based on sexual orientation when in the same position.
2 marriage bans were removed in Utah and Oklahoma, making a total of 3 ever, the first one being California. Oklahoma is also known as the Buckle of the Bible Belt, so for their ban to be removed is a big step forward. But despite this movement for change, as a nation we still have a long way to go. While these 2 couples got their victory, there are still 43 LGBTQ marriage cases in court currently, 27 of which are on a federal level. Most recently, New Jersey legalized gay marriages this October, and New Mexico followed in December. Even so, when Utah allowed marriages, they were only legal in 18 states. That's barely more than a third of our country. And after only 17 days, Utah revoked the legality of same-sex marriages. 27 states, over half the country, have constitutional prohibitions on same-sex marriages. It took 9 years for Bishop to be heard, and much longer before that to even get to that point. Our nation was founded on the principle of unconditional equality. How are we going to make the people of our country wait for their cases and voices to be heard?